All right, you're Taylon Douglas.
Yes, ma'am.
And Mr. Douglas was previously in court, entered a plea of guilty to the third-degree felony offense of obstruction or retaliation. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have,
Any additions or corrections?
no, Your Honor.
Only that court is inclined to follow judge and certainly concur with the findings.
In addition, I have received, and you guys should have been given copies of jail incident reports. Have you all reviewed those as well?
We have,
No, not that I take your word for it.
Okay. You don't like to follow rules, do you?
I follow the rules.
You do? You've been following the rules since you've been in jail? Kinda. Okay. So, how have you not followed the rules?
I don't know, just whenever, I say like whenever I get disrespected or something like stuff,
Oh, so when they disrespect you,
I just,
why do you think you deserve their respect?
cause I don't do nothing to disrespect them.
You don't? You don't? Sitting on the countertops, not getting down. Looks like trying to smoke in the bathroom, working out when you're not supposed to be working out, lying about it, saying you're brushing your teeth, teasing and cutting up with and being disrespectful, talking about the officers, act like a little kid. Taking food when you're not supposed to. Calling them some lovely names. B word. Tell them they're white and ugly.
That's what they said I said?
Mm-hmm.
I don't know, I don't remember.
You don't remember saying that? So here's the thing, Mr. How old are you?
19.
19. So you're now on a felony, or about to be, if I follow the agreement, which I don't have to do. You're about to be on a felony probation where you have to follow rules whether you like them or not because you've committed a felony offense. So you don't get to make all the decisions for yourself anymore, right?
Yes, ma'am.
Other 19-year-olds who don't do this, they get to go to bed when they want, wake up when they want, eat what they want, work out when they want. You don't get to do those things anymore because you committed a felony offense. And if you continue to act like you've been acting and not follow the rules, however insignificant you think those rules are, you're going to end up right back in here and you're going to end up going to prison for up to 10 years. Do you understand? So your life, you have to make some mature decisions as a young person who's probably not ready to make those decisions. It's going to be a conscious effort and a decision on your part to either do it or not do it, right?
Yes, ma'am.
What's going to happen if I follow this is you're going to go to ISF. ISF is a 90-day program that's intended to help you make better decisions. But let me tell you what can happen. Between now and the time that you go to ISF, you're going to be in jail. If I get an incident report, it's a violation of your probation. You could get revoked off your probation before you ever go to ISF. Do you understand?
Yes, ma'am.
And it's happened. Ask them out there. I'm tired of you young people acting like you're acting at our jail. They're tired of it. These people are just going to do their jobs, trying to go home, go with their families, make a living, pay their bills, something that you hopefully will want to do at some point in your life. Instead, they got to go to jail and deal with this. The crap from you kids. But now you're an adult for these purposes. If you get to ISF and you don't make it through that program, or I get incident reports from ISF, they send me those, you're not going to get out. You're never going to see the light of day again. You're going to go to prison. It's that serious. Do you understand? Okay. So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $500 fine, and you're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. Again, if you do everything you're supposed to, this is a great opportunity today. I don't want it to all be negative, because you have some very positive things. You don't have a felony conviction on your record. If you're a convicted felon, it changes your life in so many negative ways. You're not going to get certain jobs. If you want to go to trade schools or school or anything like that, or college, you're not going to be able to do certain things, live certain places, all of that. So you still have that opportunity. And if you get everything together and you follow the rules, at the end of your probation period, the case is dismissed. You will never have a felony conviction. This is the chance of your lifetime to change it and live like the rest of us live, okay? The other side, though, is if you violate any condition of probation, you'll be brought back into court. You'll be found guilty, so you would be a convicted felon. And then the punishment can be anywhere in that range from 2 years up to 10 years in prison. You understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Again, I know there's other people out there, there's other young people that are acting up. It's going to be up to you to say, I'm not doing it. I don't want to go to prison. All right? All right, you can go back with the bailiff. Yes, ma'am. Hold on a second.
Before he goes, Judge, in light of the fact that you are giving him an opportunity after deferred on the felony, in reviewing of his incident reports from the PSI himself and his juvenile history, which is quite extensive.
Yes.
It is my intention to proceed, obviously with a plea bargain offer on those misdemeanors, but I think it would be important, at least with several of them, to have those on his record so that if he is back, we kind of know what we're doing there.
So you won't be able to go to ISF until you take care of those misdemeanors. They'll bring you over on a jail day to get those taken care of. Ms. Molfino will talk to that prosecutor. If you enter pleas on those, great. If you decide to go to trial, then you'll just have to wait to go to ISF until those take care of with the trial, okay? Also, I do want to make sure a condition of your probation is that you are not allowed to be in the possession of a firearm of any type. That means in a vehicle with anybody with a firearm. That means at a house where there are firearms. You are not allowed to be anywhere where there's firearms. If you're living somewhere where there's firearms, you either cannot live there or they have to have those out of the house or locked where you cannot have access to them. Do you understand? Okay, you go back with the bailiff now. Okay, so I would,
They're not new cases in this court, no, but he picked up some cases.
okay. So we already went through, all right, are you Roderick Randall?
Yes, ma'am.
And so did I just reset it, or did I?
Hi.
What is
So in August, Your Honor, he pled true, and I think at that time we were looking at ISF as our agreement. It was reset for an updated report. Then we discovered he had
Yeah.
two new misdemeanors that occurred in August. And so I
Right.
filed a first amended motion October 22nd.
Okay,
So
but we need to go through
We need to
that.
enter pleas to that, and then we have an agreement if the court's okay with it.
Okay. All right. Will you waive the formal reading of the motion?
He will, Your Honor.
Mr. Randall, in clause number 24, DCCR 0543, I have a first amended motion to revoke your unadjudicated probation. And we're going to start kind of all over. I know we've gone through some of this, but we're going to get pleas of true or not true again on all of them.
And Your Honor, with your permission, we've agreed to plead to 1, 2, 3, and then the amended counts of 10 and 11, which cover the several new offenses, all
Right.
misdemeanors, but
Thank you. So it shows you were placed on probation October 7th of 2024 for aggravated robbery, and that was a 5-year deferred probation. Is that correct? The state's elected to proceed on counts 1, 2, 3, 10, and 11. Count 1 alleges that you violated your probation by committing the new offense of unlawful carrying a weapon May 3rd of 2025, and is that true or not true?
True.
Count 2 alleges that you committed the new offense of evading arrest or detention May 3rd of 2025, and is that true or not true?
True.
Count 3 alleges that you possessed a drug, marijuana, May 3rd of 2025, and is that true or not true?
True.
Count 10 alleges that you committed the offense of unlawful carrying a weapon July 13th of 2025, and is that true or not true? And then count 11 alleges that you committed the offense of evading arrest or detention July 13th of 2025, and is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily? And did you plead true to those counts because they're all actually true? I have paperwork now, again, on the case here that has your signature on it that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Randall's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the offense of robbery, aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institution.
Judge, I feel like we may have originally pled him to lesser.
I think we did lesser
robbery.
included.
Let me double check. And it may be because he's one of several co-defendants in that case, and I know at least one of them was pled to a lesser.
I have that we did plead him to a lesser included robbery back in August of 24.
That's correct, Judge. I'm looking at the PSI.
Let me double check with the paperwork, though. Hold on just a second. Can you pull up the original? Well, never mind. It'll probably be in here. Never mind. Hold on.
It was pled down to judge robbery.
Okay. Does the state want to?
Yes, Your Honor, I'd ask that you be allowed to amend the motion to take out aggravated, reflect the original.
Any objection to that?
No objection.
So I'm going to go back, and just to make sure the record's clear, what you're on probation for is the lesser included offense of the second degree felony offense of robbery. So it's not aggravated, it's the second degree felony. And I'm going to make that modification amendment here on the motion with, let's see. I can figure out how to get all this done. Okay, so that being said, I'm going to find you guilty based on the pleas of true to counts 1, 2, 3, 10, and 11. Find you guilty of the offense of robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
All right, court's just going to, I just need about a 5-10 minute break. We'll be in short recess.
All right, court's in recess.
Denzel Spikes. Okay, you're Denzel Spikes.
Yes,
Will your client waive the formal reading of the motion and the indictment?
He does, Judge.
Judge, we're just proceed on count 1, on allegation number 1, we'll ban the rest. That is the condition.
Mr. Spikes, in cause number 25 DCCR 0921, you're charged with the second degree felony offense of aggravated assault with a deadly weapon from April 29th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents in that case that have your signature on them that the state's marked as exhibit number 1. I'm gonna need some explanation.
On,
The punishment,
on his 3, Judge,
he's on probation for aggravated assault with a deadly weapon, commits another one.
just, the newest one was not as egregious as it seems. It was a kind of a mutual combat, but we,
Okay, let me look at
therefore, we're proceeding on that with the lower offer due to the nature of it, but not to continue him on probation.
Okay, give me a second. So give me just a second, I'm going through a couple things. Okay. All right, so I have, again, some paperwork here that has your signature on it. Did you go over that with Mr. Lewis?
Yes, ma'am.
Do you fully understand it?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Look at one more thing before I do this. Let's see, 24. I'm printing something. Bless you. I'm just looking now at the PC from the original case. I'm looking at the PC from the new case. Let me see if I can go back. I'm also gonna take a look real quick at the PSI. I'm just not feeling real comfortable with that low. I understand in the new case, potentially some issues if there was some mutual combat, but the underlying offense and the fact that we're resorting to the same thing and grabbing things and beating people with them is concerning. No criminal history. All right, state tenders number 1 in 25 DCCR 0921.
No objection, Judge.
It's admitted. Any evidence Mr. Spikes is not competent.
No, Judge.
All right, sir, in cause number 25 DCCR 0921, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 3 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1642, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 18th of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges in the state's elected to proceed on count 1 only. It alleges that you committed the new offense of aggravated assault that we just with a deadly weapon, the one that we just went through, April 29th of 2025. And is that true or not true?
True.
Did you enter your plea of true to count 1 freely and voluntarily? And did you plead true to that count because it's actually true? I have here on the tablet also some paperwork in that case that has your signature on it. Before you signed it, did you go over it with Mr. Lewis? Do you fully understand it? And do you understand, again, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection, Judge.
It's admitted. Mr. Spikes, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 3 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in each of these cases. I'm handing you the trial court certification in each case that shows these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff. Thank you, ma'am, for being here. Ms. Richmond, in cause number 24, DCCR 2306, you're charged with the state jail felony offense of theft with previous theft convictions from September 9th of 2024. The indictment alleges you were previously convicted of theft June 21st of 2019. And then after that was final, you were convicted of theft in 2 cases on the same date, March 21st of 2024 in Bell County, and then again April 10th of 2024 in McLennan County, Texas, and May 31st of 2024 in Collin County, Texas. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
And are those prior convictions true?
Yes, ma'am.
What are the outcome of those last few, 2024 cases?
Judge, I've got the one with 2023, where she in Hayes County. Is that the one? I believe that. Is that
I don't even have a 2023 Hayes County in here. I've got
I've got
2 in Bell County, 1 in McLennan, and 1 in Collin.
Colin. We got 200 days in county jail,
Okay.
and let me pull the Bell County. Bell County was 9 months.
What about McLennan County?
It was 4 months. I think it was a misdemeanor. 4 months.
I believe
Okay.
most of these were punished as a misdemeanor, 1244, Judge.
Well, you've got one. The Bell County's out of a district court.
Yes, ma'am.
And the Collin County's out of a district court, which they could have pled them down, but those are both.
This is a state jail. The Bell County was the one in 2024. It's 9 months state jail. And the Collin County one, like you said. I know. The Collin County was a 1244 to be specific, Judge.
Okay. Let me look at something. I don't think I like it. God, they're so hard to read. I'm printing the PC, I can't see it. Okay, PC. So there's a case from 2017 here out of this court for a 2-year term in prison. What was that for?
No, I had, 2 years probation, and then when I went to jail, I had got some jail time with a 1224A. I don't know how much it was.
So what I'm looking at here, which is even more than what's included on that indictment,
Yes, ma'am.
shows a 2017 conviction for theft here in Jefferson County, a 2023 in Collin County, a 2023 later that year in San Marcos.
Hayes County.
I was
Hayes
in jail
County.
that whole time.
I don't care if you're in jail. I care that you're continuing to steal, and that I'm not sure that this deal that you've made is sufficient for what I think, for what you've been doing. So we're not talking about a long time ago. We're talking about the last 2 years. So going from literally from county to county to county. So we've got Collin County, Hayes County, then we're into 2024 where there's 3 convictions, one in McLennan County, one in Belton County, one in Kaufman County. And we're back here with an offense date. So the offense date here was 9/9, which is actually of 24.
Yes, ma'am.
Okay. So at least that one was before the Kaufman County. So you went from here and then you traveled to Kaufman County, within 3 days, got another case there. Or at least you had it before and that was the conviction date. Yeah, nope. I will keep the paperwork. Y'all can go visit. I don't think 12 months is appropriate, somewhere. There's gotta be a little more than that, in my opinion. Otherwise, obviously, jail time has not been sufficient to deter Miss Richmond from going county to county and stealing places. So y'all take another look at it. I won't delete it. So if y'all come up with something, I can make that adjustment. If not, if you need some time, I'll reset it and then y'all can talk.
Yes, ma'am.
All right, you're Andre Williams III, and this, the second, this is cause number 24 DCCR 1539. Mr. Williams charged with tampering or fabricating with physical evidence, and cause number 24 DCCR 2286, charged with murder. We're here on an announcement. Mr. Vasquez has also filed a request for me to attach some records, some Social Security records.
Yes, sure.
I've signed an order already ordering those, and they're not complying, Social Security Administration, with.
Your Honor, you signed an order on September 8th, and I sent it certified mail to the regional office in Dallas. Someone received it there on the 24th of September, but I never got a green card back or any return receipt. And this is the next step I took. I would have just asked for more time, but I thought I'd better file the application for a writ.
So I guess my question would be, if I sign an order for writ, who goes in, I mean, who's gonna go, are we at? Let me look at this, because,
Big burly Dallas County Sheriff
goes and does it,
grabs them.
grabs the paperwork, or the person? I guess that's what the question is, because there's a hearing request regarding attachment. Is there a motion for the attachment of the person or the records? That's what defendant's hearing request.
There was an earlier motion, Your Honor, and then there was a motion that the court signed
Right,
compelling
right.
compelling the Social Security office to turn over the writ.
I guess what I don't have that I think to make it clean I need is the petition for the writ. I don't see a petition for a writ of attachment. I see a defendant's hearing request regarding an attachment, so we can have a hearing, but that's not actually got the key language probably. Well, let's see, the moves this honorable court to issue a writ. So I think it probably is correct in the body of this motion. I think it's just the top doesn't. Mr. Nichols,
Judge, I don't have a problem proceeding with this as a application for a writ because I think the language says that.
I do too. What is the, I mean, without getting into, I guess, a lot of information, but the necessity with regard to getting these specific records, is this something that, with regard to the relevance in the case?
Judge, I believe it would be material if we reach the second part of a trial. It's
The second part, punishment, if he's
Yes.
found guilty? Okay, you can say the words. Mitigation
Yes,
evidence
thank you,
and
Your
a
Honor. Mitigation.
punishment hearing?
And
Okay. All right, so I'm gonna grant. So I'm gonna grant it. I do think, however, I need a more specific, so the order is just saying that I'm granting the writ. I need a writ now prepared of attachment that has all the specific information in it that will go to Dallas County. Look at the signature line. For me, my signature line.
Is that an autocorrect?
Judge, you both look so much alike that
Yeah,
That's the only way to say that. Your Honor, I don't have any issue with him.
I think we have to
Keep
do
doing
a
the steps
writ.
to get these records.
Yeah.
I don't want to keep delaying setting this for trial.
No, I
if
don't-
That's where we're headed.
I
think we've already
agree.
done a rejection of an offer.
So let's do this. I'm going to go ahead and place it on the trial docket. I'm going to grant the writ, so you should be able to hopefully get somebody to go work on getting those documents. If something happens and you can't, and there's some issues, obviously just let me know. We'll get back in here. But I need more than just this order. I need a writ of attachment that has your, Dallas County, your order to go get X documents from blah, blah, blah. Obviously, it needs to say something different than that. It needs to say what you want from them specifically, where to go, address, custodian of records, all of that needs to be in a writ. And then we will get that to us filed, and then we'll get it the appropriate way where we need to. We just haven't done these very often, so I'll look up exactly how to do it, but I think I need the writ itself prepared.
I'll try and get the right signature line this time.
Thank you. Make that adjustment on there too.
Please
All
tell me
right,
I'm not the
you can
first
go
one
back with the
do
bailiff.
that.
All right, ma'am, are you Destiny Williams?
Yes, ma'am, I am.
Will your client waive the formal reading of the motion in each case?
You will in each case, Your Honor.
And Judge, just for a little bit of procedural history, because it took Mr. Burbank and I a second to figure it out. Irrespective of the fact that the motion itself in the language does not state she was extended a year, then 3, then 4, she was. Well, I went back and looked at her original records, so I believe that at the time this motion was filed in September of 22, it would have told that probation that was set to expire, but the motion doesn't read that way because it doesn't have the 1 in there. I can do
Okay.
an oral motion to amend that 1-year extension. but
No,
there were
that's okay, as
3
long as you guys both agree and it appears that that,
extensions in total to make that 2012 case run to 22, and this motion was filed so prior to it discharging.
okay, all right, and you agree with that as well, Mr. Burbank?
I don't want to, Judge,
But you do agree to that as
but yeah,
well?
it's information they had and I didn't. and
Okay. All right, so we all agree that there was a 1-year and then a 3-year and then a 4-year extension in cause number 12-14477. Okay, and probation's here as well, and is that your understanding? Thank you, and thank you for your patience this morning. Okay, so will she waive the formal reading of the motion in each of the cases? If I didn't know. Ms. Williams, in cause number 12-1477, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation November 5th of 2012 for the offense of robbery, and that was initially a 3-year probation deferred that was extended several times. Is that correct?
Correct.
And then in cause number 19-32216, I also have a motion to revoke your unadjudicated probation. This shows that you were placed on probation September 25th of 2019 for the offense of illegal transfer of EBT benefits. And that was a 5-year probation deferred that was extended at least 2 times. Is that correct?
It was extended once from my understanding.
It looks like it was extended for 3 years, December 2nd of 2016, and then another 4 years,
Was she put on 19?
I didn't get the illegal
19.
food stamps.
Oh, 19, so it would,
17.
yeah, you're right. Okay, so it was extended 1 time.
Yeah.
Okay. I'm gonna mark that out.
So we'll just
Abandon that.
strike that 3-year extension, if you would, Judge.
Okay, so it was extended 4 years from the original date, correct? Just 1 extension in that case.
To my knowledge, I completed it, but with me going on the run again, it was counted like I didn't complete it. I paid my stipulations and
Well,
Follow
that's
the
how it works,
procedure.
is there was a motion to revoke filed before it was over, and so that tolls it, so you didn't complete it if you went on the run. Right? Completing it means you successfully complete probation, doesn't just mean the
Well, not
time
all.
passes.
well, just the food stamps. I signed paperwork saying that I completed that part of it. And I was off my case for a whole year, from my understanding is what my probation officer had me sign. But yes.
So probation's here. Ma'am, if you'll just please state your name for the record.
Alexandra Robinson.
And Ms. Robinson, do you have the file in 19-32216?
I did have it in my file folder over there.
Would you just double check in that real quick and make sure that there wasn't something, do you have any personal knowledge, or do you need to look at it to see if there was something
I
signed?
need to look at it because I took on her case in August of 2024. I have not seen her in the office. So a lot of these things would be from her previous offices,
Well,
but I can look in the file.
I'm looking back, it would be in my file as well if there was a dismissal of the motion. I mean, if the case was satisfactorily completed, so no, you got on probation September 19th of 2019. There was an order of deferred adjudication. There was an administrative hearing in August of 2022. A motion to revoke filed in 2022. And here we are because you've been gone. So your probation obviously wasn't over. Okay, we're good. Okay. And is there no agreement? There's not an agreement?
No
If-
agreement other than.
If there's no agreement, we're gonna go through the whole motion. Yeah. I want I want everything, in front of me that I need. All right, so, Ms. Williams, in each case, count 1 alleges that you failed to report to the Jefferson County Probation Department as ordered March 10th, April 29th, and May 31st of 2022. And is that true or not true?
True.
Count 2 in each case alleges that you failed to report for a judicial review August 22nd of 2022. Is that true or not true? Count 3 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. Is that true or not true?
That's half true. She wasn't reporting, so she couldn't report that she was working, but she had employment, which would probably come.
And provide verification of it.
That's right.
So did you provide verification of it? Of working? If you weren't going to probation, then I'm assuming you did not.
Right.
Okay, so is that true or not true?
True.
Count 4 alleges that you failed to immediately report to the probation officer your change of address. Is that true or not true?
Is that not true?
It's not true.
That's not true?
It's not true.
Okay. Count 5 alleges, count 5 in cause number 19-32216 alleges that you failed to provide verification of performing your community service hours as ordered. Is that true or not true?
Did you do all your community service hours?
No, I didn't do all of them. I was pregnant like almost every.
It's true or not true? Did you fail to provide verification? This is in the illegal transfer of EBT benefit case.
What about it?
It alleges that you did not provide verification of performing the community service hours as required. Is that true
I
or
didn't
not
complete
true?
all of my community service, but I was doing.
Is it
community
true
service.
or not true?
It's not true.
Okay. Count 6 in that case, in the 2019 case, alleges that you're behind in your court-assessed fees as of August 22nd of 2022 in the amount of $2,956. Is that true or not true?
It's true.
And then in cause number 12-14477, count 5 alleges that you failed to pay your court-assessed fees as directed, and that as of August 22nd, 2022, you were behind $3,353. Is that true or not true?
It's true.
And count 6 in that case alleges that you failed to successfully complete the Impulse Control Education Program. Is that true or not true?
I didn't know I had a drug.
That's true, you didn't do it.
It's an Impulse Control Education Program.
It's anger management.
I don't know what it is. Did you do it?
No,
Okay, so it's true.
it's true.
Okay. Did you enter your pleas of true in each of the cases to counts 1, 2, 3, and then in the 12 case, 5 and 6, and in the 19 case, 6, freely and voluntarily? And did you plead true to those counts because they're actually true? Okay. In each of the cases, I have some documents here on the tablet that have your signature on them. Did you go over those with Mr. Burbank? And do you fully understand them?
Yes.
And there's no agreement.
No.
So,
You know, you're gonna have to modify the paperwork in reference to the counts. Or do you have to?
yeah, well, yeah. I don't really know that. Okay.
We alleged counts 1 and 3.
Y'all filled out an agreed punishment recommendation paperwork instead of unagreed. So that's an issue because it's not agreed. And so if it's not agreed, there are some rights to appeal, and you've also signed the post-conviction waivers. So,
Well, we agreed on the 1 and 3, that's probably the reason why we did. I did.
but if you're leaving it up to me, I want to know how she's done on probation.
Well, I thought you would get that in reference to the PSI report.
But I want to know if she takes responsibility or not. I mean, I need to know all those things. So, okay. I'm going to mark through the post-conviction waivers because it's unagreed. I'm just going to write unagreed here, so we don't have to do it over. And I'm going to write it's not a plea bargain there. State tenders number 1 in each case. Did I already do that?
No objection, statesman.
It's admitted in each case. Any evidence that Ms. Williams is not competent?
No, yeah.
All right, I'm going to find that you entered your pleas of true to the counts you pled true to in each case freely and voluntarily. Find those counts true in each case. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case so that the probation department can do an updated report. That'll give me more information about you and your cases, and then we will come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Burbank, and he will present it to me on your behalf when we come back.
One thing, Your Honor, it is deferred. I would ask that a bond be set. I know that she has not reported. She was working full-time. and
She
has
just
been.
admitted in front of me that she's been on the run, and so I think based on that, based on the nature of the fact that she's been extended, we have a case from 12 and 19, and that there's not even the possibility in the 12 case for anything other than a revocation because of the dates, that I'm going to deny that request. All right, you can go back with the bailiff. Mr. Burbank, Mr. Malfino, and sir, again, you're Brandon Bell. And so, well, just to get us back where we need to be, everybody's reviewed pre-sentence report, made argument. I want to go back just one more time and see. I know, Mr. Burbank, you're asking that I continue Mr. Bell on probation. Ms.
With
Mal-
treatment, Judge.
with treatment. I know Ms. Lopez has made her position very clear. Ms. Malfino, what is the state's position?
Judge, I certainly have ultimate respect for Ms. Lopez's position. She knows the defendant and what she's been dealing with a lot better, probably has a slightly different perspective on the kid other than what I do, so I certainly defer to her opinion. I also, at the same time, agree that probably the SAFE-P special needs to address that synthetic marijuana issue may be relevant. Has he had that opportunity in the past with some other charges? Yes, very well so.
So what,
Revocation may be appropriate, Judge, based on the underlying offense itself. If it is not, of course, we would be of the opinion that if he goes to that and violates zero tolerance in any way, shape, or form, we ask for the max.
okay, I'm just reminding myself also, so what I did not do previously was go through and take a look at that old pre-sentence report, which has the criminal history, which includes
Several sentences in prison.
already been to prison, given an opportunity on probation in 2020, which is not long ago, 5 years ago, revoked and sent to prison for 2 theft cases. One was a TDC case, given 3 years. And so pretty much gets off parole barely and commits this offense, gets the opportunity at probation, and we're where we are now.
And he does have an extensive juvenile history, you will see in misdemeanor as well. And again, that's why I
Yes.
wanted to let the court know that that underlying probation offer was made with the issues with Miss Adriana Bell that the court is obviously aware of by this point.
Okay, I am looking back at history, juvenile history, going back to 2013. Assaults, violation of court orders that look like it should have ended up in Texas Youth Commission. For some reason, they kept putting you on probation all the way until 2018, when you apparently become an adult. Then you start getting felonies and misdemeanors, get probations on all of those. Those are revoked. You beat the mother of your child while she's pregnant. You get a 5-year deferred probation, and you don't take advantage of that probation. I feel like at this time, what Ms. Lopez said is absolutely correct. You are a danger to your children, you're a danger to the menace to our county, and have been since 2013.
Just one thing. Do you know when his mental health was discovered?
I wasn't.
Probably when he started using synthetic marijuana. So at this time, I'm going to find that you entered your plea of true. So you were previously in court, entered pleas of true to counts 2, 3, 4, 6, 7, 9, and 10. And then today, I am going to make a finding of true to counts 1 and 8 based on the testimony of Ms. Lopez. I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon. I'm going to sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And I'm going to hand you, and y'all need to sign this, trial court certification that shows this was not an agreement. There are some rights to appeal. You can talk to Mr. Burbank about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you. Hang on. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. You need to sign that, and then I'll get you a copy of it, and then you can go back with the bailiff. I do think that's fair, and hang on to, Mr. Bell, I can go up to 20 years today. See, this is, talk to Mr. Burbank about that. Yes, sir, thank you. That's weird looking, I don't know why. Okay, are you Jamarian Martin? And Mr. Martin was previously in court in cause number 25 DCCR 0196, entered a plea of guilty to burglary of a building. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
I have, Your Honor.
Any additions or corrections?
Nowhere, Judge.
Only that the state would request $500 in restitution, Judge. I think my conversation with the PSI author in this case, Ms. Banks, was subsequent to her already sending it to the court, so we were able to determine it's $500 in restitution.
Okay.
And I would also ask if the court is inclined to follow it, that it be with a condition of ISF at the very least.
So that's, yes. So my biggest question is, with regard to ISF, it's either substance or cognitive. And so because there's some drug issues, but there's also, he's young, and so what I'm considering is ISF cognitive and then JCDI as when he gets out. Does that seem appropriate for what we've got here?
I think so, Judge.
I think so. He came to court and tested positive last time, but
Right.
it probably would better address both with both of those programs. And then we could always follow up with something.
Yeah. Well, or, yeah.
Let's not go that route.
Let's- Okay, Mr. Martin, what I'm going to do, how old are you? 19. So my goal here today, and everyone's goal, is for you to be able to be successful. And so what's going to happen is you're going to be given some tools up front, not necessarily meant to be punishment, but meant to give you everything you need to change your life and be successful and go through this probation. So what that means, though, is if I do all of this now and then you violate later, coming back in and asking for another chance is probably not going to go very well. You understand? So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. I am going to order $500 in restitution and that you follow all of the rules and conditions of probation. That's going to include entering and successfully completing the cognitive track of the ISF program, which is a 90-day program to help you make better decisions. And then when you get out, you're going to be ordered to enter and successfully complete the JCDI program, which is the Jefferson County Drug Intervention Program. That is an outpatient treatment program, but it's intensive and it's meant to help you get off all the drugs and things like that. So you're going to be able to be hopefully making better decisions, not using drug. And if you do all of that, this is an excellent opportunity because you're not a convicted felon. You don't have this felony conviction on your record. And if you successfully complete the probation, you will never have a felony conviction. The case will be dismissed at the end if you're successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, convicted of the offense, which means you would be a convicted felon and sent to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. Sorry.